well. So, let's move into public law. So, I kind of discussed at the beginning that the Australian legal system is very heavily based. I'm turning the brightness down on that. It's very aggressive to me. That the Australian legal system has been primarily based in the UK because that's what was imported here with colonisation. However, it's also very different to most other Commonwealth nations in that it takes the lead from America because it was properly, our government was properly set up after our initial legal system was set up. It's colloquially referred to as the Westminster system because it's a synthesis of ideas like federation, federalism, and a constitution from Washington, and responsible government and parliamentary sovereignty from the Westminster system. Now, our Australian legal system works as follows. The key to the system is a separation of powers. Now, what that means is that each element of government keeps the others in check and working correctly. Both Westminster and Washington have this within their system. It's a key system. But it's not just enshrined in our constitution in terms of giving us that, the judiciary will be in charge of the high courts and may determine matters of blah, blah, and the executive may do X, Y, and Z. But it's also about parliamentary convention. Now, conventions come from primarily the Westminster side of politics. So the UK does not have a constitution. The reason for this is they rely on conventions and this notion of, as I said, responsible government. Now, what does that mean? Because it's pretty vague. And how can you, how can you even uphold convention? Like, you can't impeach someone for doing a convention because it's convention, it's not a law, right? Well, how this works is for the theory of responsible government that says parliament's a representative, and that means that if someone behaves badly and subverts conventions, the people will vote them out. That's what it relies on. It's a little bit probably naive now, maybe? I'm not sure. It's a probably mildly flawed system, isn't it? Now, the flip side of that being obviously that sometimes constitutions become deeply disconnected from what they were originally meant to be seen as. So America being a strong example of this, there's about, a heap of amendments to the Constitution, and, there's the controversial ones about, Second Amendment rights, which may not be as applicable today as it was when it was created with muskets in mind. But responsible government is about the fact that the people have power. Parliament is the representative of the people, and that's where parliamentary sovereignty comes from, which is a UK concept, i.e. Parliament is more important than anything else. Representative Parliament, that being, which is important in the UK because they have two houses, but one of them is not a representative house, it's a House of Lords. Now, we can see there's quite an immediate example, I think, that comes up in regards to responsible government in terms of being a convention that's upheld, is it does rely on the people being aware of things that have happened. And I think there are two pretty solid examples of this one, and one didn't need to go to an election because it happened at a point. The UK has elections, I think, every 6 years, or at least they're meant to, so wouldn't have come up to an election, is the party scandal for Boris Johnson. If the people hadn't known about that, even though potentially he breached some type of convention, the convention in this case is just like being a decent guy, people may not have known about it. And then how can you say responsible government works if the people aren't aware? Now, I think the most pressing example of this is the current big issue, that's probably Australia's second biggest constitutional issue since the 70s, which is the issue of former Prime Minister Scott Morrison swearing himself into multiple ministries. So for those of you, again, that are chronically online or into politics, we found out not long after the election last year that Scott Morrison, during the pandemic, made himself Treasurer and Minister for Health and Minister for Environment and all these things. He only used the powers once to stop a offshore oil rig. Ironically, a really, really great thing that now has to be undone and re-go through it again, which is annoying. But that is, and quite often what was said is the commentary was like, this is a severe breach of our Westminster heritage and, of responsible government. And I'm sitting watching the news and going, I know what that means. But that's another thing. That only came out after the election. Had it come out before the election, I think everyone would have gone, oh yeah, that's not responsible. Let's vote him out. Had he been re-elected, we probably would have never found out, which is a bit of an oof in that regard, in terms of responsible government. So it relies on knowledge of what's going on in government, basically. Now, as I said, that's kind of how we uphold conventions. The interesting thing here is that also that Australia's legal system, although it relies on the separation of powers, isn't technically separate to the extreme that America is. So in America, you obviously have your houses of government, your Senate, your House. You have your president, who is represented, comes from a party, but he's not elected as a representative of that party. He's elected as a dude. Joe Biden was elected because he's Joe Biden. And then you have Joe Biden's ministry of all his executive, which is, the Secretary of Defense and blah, blah, blah. And that's people he's just picked. In Australia, we obviously have slightly different in that our executive comes from our legislature. So Anthony Albanese is the leader of the Labor Party. We don't vote in Anthony Albanese, you vote in the Labor Party. And his ministry are members of the legislature. So there's a slight overlap there, which I don't think is necessarily a bad thing, because I think that enshrines that notion of responsible government. If someone acts really poorly as a minister, they're probably going to lose, they're going to get booted to the backbench. But it is an interesting thing to consider. And you can also see the judiciary is involved there. The other interesting thing to note, just to go in a bit further, is obviously our constitution. Our constitution is a bit vaguer than the US Constitution, which I think for all intents and purposes is a good thing. I discussed what responsible government means. I'm going to discuss a little bit more about federalism and parliamentary sovereignty. So I briefly mentioned parliamentary sovereignty. It's basically the idea that because the people elect parliament, now this is a UK notion because, as I said, they've got two houses. Because the people elect parliament, the House of Representatives should take precedence over the House of Lords in this case. So the House of Reps could do whatever they want because they are the more important ones. Now, in Australia, that poses a bit of an issue because our House of Representatives is not the only House of Representatives in theory. We also have the Senate, which is also elected. So we have a bit of tension here because there maybe as a whole parliamentary sovereignty over the executive maybe, but the Senate isn't more, it would be untrue to necessarily say that the House of Representatives is more important than the Senate. Technically, the Prime Minister in the UK and Australia gains their power from the House of Representatives. So whoever has the most seats in the House is elected government, the governing party. The Senate isn't included in that calculation. So technically Parliament, in the sense of the House of Representatives, has sovereignty over the Senate, but it's a little bit of a tricky issue there because they both are elected. They're both meant to be serving out the will of their electorates or their states. So you do get a bit of an issue here. This issue comes to a head, and we're going to discuss it in a second, during the dismissal of Gough Whitlam, which also reflects this second one. So we have parliamentary sovereignty, that refers to the House of Reps. Federalism deals with the Senate. So federalism refers to, now this can feel a bit confusing because we have our federal government, which is kind of like national government, right? Federalism in this case, from the American system, refers to states. So we know in America, they take federalism to the extreme in that the states' rights are super duper important because they've gone to war heaps. They'll go to war heaps about it. And it's obviously very topical at the moment with things like a women's right to choose. And we've also got these issues currently with other laws that may revolve around the vulnerable, like transgender people. So we have this disconnect in America between federals, the states, and the actual national government. The national government can step in, but like the last time there have been kind of 2 times the national government has stepped in and legalized stuff. The first time was slavery, didn't really end well. Second time was about the civil rights stuff. Probably only ended well because JFK had just died, right? In Australia, we don't take it to that extreme, right? Our states still ultimately have to adhere to high court rulings, just like the Supreme Court in the States. And generally, there can't be too much contrast between state decisions and what the national kind of memo is. Now, there can be, absolutely. And we've seen that, for instance, with the ACT at a point legalized same-sex marriage before any other state, and then when it was made wholeheartedly illegal at a national level, that overturned the ACT's decision, and that went to court. That was the whole thing. I don't know the specifics of that. I couldn't tell you the year, but it was quite a thing. I vaguely remember it. So we don't take it as extremely as America, but we still have this tension that our states have rights, but more importantly, our states are represented at our national level through the Senate. So the Senate works that states are afforded X amount of seats each, plus the territories get 2 each, ACT and the NT. It's meant to be equally represented. WA has the same amount of senators as New South Wales, so that New South Wales can't shout out WA issues. Because if it was based on population, you'd have the problem of New South Wales wants to dig up WA because they've got heaps of minerals, and the whole Senate's like, hell yeah, that's a good idea. And the single WA senator is like, no, maybe don't. So it's about protecting the rights. But now we have an issue in that the House of Reps is meant to be the representation, but we still have the states vying for their people. And this comes to a head, as I said, during the dismissal of Gough Whitlam, which we'll chat about in a second. So here's another little diagram from the government specifically about the judiciary, the exec, and the parliament. I'm trying to figure out if these are people or if that's just little cartoons, because I'm like, those ears do be looking like Tony Abbott's ears. But that's our... Maybe. I can think of people, but I might be reading too much into it. So, judiciary, power to make judgments on the law. Parliament, power to change the law. Exec, power to put the law into action. Sitting alongside the law, as we've said, is admin law or public law kind of governs what a government body is allowed to do. In the criminal system, you can appeal a decision, or in the civil system, you can appeal a decision. But what about when a government body does something? So you have a Centrelink decision, an NDIS decision, and you think it's wrong. You don't want to sit and just take it. So the first thing you can do is about if you think it's the wrong decision, you can opt for what's called a merits review. So i.e. was the case decided correctly? This is reviewed by a tribunal, and generally the Administrative Appeals Tribunal, which is currently being destroyed and reset up because it's kind of fallen apart a bit. Ideally, it's meant to be an independent body that assesses whether the decision was correct. It's not I don't like this, fix it. It's they will then go through the decision-making process and see if they would disagree with that. Now, this has become controversial. I'm not going to get too bogged down in it. Members of the AAT are meant to be independent. Over the last decade, it's become significantly less so. It's kind of been a jobs for the boys endeavour, which is why it's being disbanded and set up, which is a good thing. But for those of you, when you study admin law, it will look very different potentially to when I studied it, which is pretty cool. If the AAT makes a call that you further disagree with, you can then appeal it up. Tribunal merits review is meant to be more informal. It's meant to be you can come Even if you don't speak the best English, you can bring a translator in. You don't need to have a lawyer. It's more a discussion, right? It's an investigative process about whether the right decision was made. This is contrasted to judicial review, which determines the legality of a decision. So you get a decision from the NDIS, for instance, or immigration, and you think it's just not just the incorrect decision, you think something illegal has happened or something wrong has happened in the process of making this decision, and the decision shouldn't even be valid anymore. So that becomes then a more formal process with a proper judge. Not that the tribunal members aren't proper people, but this is a legitimate, it goes to federal courts. So the judiciary in this case can hold the executive, the ones who made the decision through their delegates, to account. A decision can be challenged on the following grounds. So a fact-finding error, you just straight up got the wrong information. Unlawful delegation, a minister is meant to have made a decision but has instead not really done any of it. Someone else has done it for him and he's just signed a paper. The case of this is if you Google Alex Hawke, I think US immigration case. This is a case where he was found to, within a drive from Sydney to Canberra, so 3 hours, had simply made a decision on an immigration case that was quite complex. He did it in the car. There's a photo of him in the car signing it. And it was challenged on the basis of he obviously hasn't read that. And it was found that, yes, someone else has done the work for him and he's just given his signature. Procedural fairness is also a key issue. This is generally split into two: rule against bias and the rule of a fair hearing. A fair hearing says that an individual who is going to be impacted by a decision has the right to contribute to that decision-making process, either by putting information forward or something like that. So they have to be told what's being discussed, give them the opportunity to respond. Rule against bias is what it sounds like. You can't be making a decision that might be biased. Errors of discretion, if you have, or maybe that's the Alex Hawke case, I might be lying. No, that is not the Alex Hawke case either. So this is where discretion has been used incorrectly. So if the law is slightly flexible, you need to still be reasonable in that regard. So you can't consider something that has no bearing on the case, even if you're technically allowed to consider those things. Unreasonableness is about, was this decision, it kind of goes a little bit back into merits. Was this decision so unreasonable that no one should make it, basically. And then fettering discretion and jurisdictional error are slightly different. So jurisdictional error is a way of describing whether the error that's been made, be it unlawful delegation or procedural fairness, goes to the heart of the issue. Should the issue be invalid? And fettering discretion is also about, have you told someone else to do your job for you when you shouldn't have? So I'm actually going to skip this because I want to cover the criminal law and get to some questions. For those of you that want to get some prep on for your public law course, do a little bit of Googling about the Whitlam dismissal and have a think about why this case could really only happen in Australia. So why does this case of Gough Whitlam, the Prime Minister being dismissed in 1975, demonstrate that there's a tension in the Westminster system? So that's where federalism and the Senate comes in. The Senate being still representative, Parliament and the House of Reps still technically being more important, those types of things. Where does it come in? And also the very nature of a constitutional monarchy, being able to dismiss an Australian Prime Minister. Okay, let's do some criminal law now. That's also been compressed to goodness. This is kind of the one everyone thinks about with law, right? This is the traditional, like, let's get into the nitty-gritty, dirty cases, right? So criminal law, as I mentioned, is about the state governing its people. It's very interesting to get into a moral or critical reading of crime because it's generally, criminal law has an element of morality to it. It's about what society says should be frowned upon. What does society need to punish? So obviously things like murder and assault, they're not great. They're not ideal. But the moral limb of the law has also been incorrect historically. So I've put up there things like drug use being criminalized instead of maybe seen as a health issue, or even things like potentially more benign drug use like cannabis is illegal, but alcohol isn't. Now you can also look historically at the things that have been illegal that now we look back on and go, oh, that is not a crime. So same-sex relationships or civil rights aspects have obviously all changed significantly. So crime is very much a fluid thing, like a lot of the law, as we're discovering over this lecture. So to make out a crime, there needs to be some elements proved, which we're going to discuss about, but even though there's not a slide. But even more important to an extent, even before you can get into the courtroom, is the notion of criminal responsibility. So for us, we're going to talk two things: age and awareness of a crime. So the first about the age of criminal responsibility is a very it's a very topical debate at the moment. Again, for those of you that I follow politics a bit. So the principal law is Dolly and Compax, which is that, the child cannot be evil, basically. So it says that a child between the ages of 10, which is the age of criminal responsibility in Australia, and 14 may not know the difference between wrong and right in certain circumstances and may not be held responsible. This is all made. It's a rebuttal presumption. So the prosecution has to say, no, the child didn't know the act was wrong, and here is the evidence to support that. It can't be, no, of course the child knows it's wrong. Stealing a car is bad, because, I don't think that case would, I think that would work. But it can't just be rebutted on the basis of the crime is severe. So it's also dependent on the age of the child. If you're, 13 and 9 months, it's going to be pretty easy to rebut Dolly and Compax versus a fresh 10-year-old. As I said, this is an area of debate at the moment for the raise the age movement. So it suggests that children should be diverted away from the criminal justice system, especially when institutional biases are taken into account. So something like, every child in the Northern Territory in prison is Aboriginal, so we need to take into account what is the impact of these laws. So the ACT has said they will move that 10 up to 14, that 14 years of age will be the age of criminal responsibility. And a bunch of former New South Wales Attorneys General have recommended that New South Wales should raise the age to 12. Which will be interesting after the election to see what happens there in New South Wales. So that's the principle in terms of the age of a child being a big deal. In terms of criminal responsibility from understanding the crime, it's also important that law cannot be just to find someone responsible for an act that they did not know was wrong or unable to understand was wrong. This doesn't mean someone say, oh, I didn't know that was a crime. Like, ooh. It means that someone physically or psychologically could not comprehend what was wrong. This original case is called McNaughton. It's the McNaughton standard. And this is an international standard. It's an old English case that's used in the States. Still, it's used over here. It's obviously developed. There are more modern cases to use now, but this is the traditional foundation to establish the old defense of insanity. So it said it must be clearly proved that at the time of the committing of the act, the party accused was laboring under such a defective reason as to not know the nature and quality of the act, or if he did know it, that he did not know that it was wrong. So there are two issues that you prove one or the other. So, however, it's often kind of seen in the media that like this is a get out of jail free card, that it's like, okay, like cool, I did it, I didn't do it, woo, free me. A verdict returned is a verdict of act proven but not criminally responsible, and the offender will then be transferred into the care of the Mental Health Review Tribunal. So they'll be taken generally to a care facility, basically a jail but a hospital, and they'll be reassessed at certain points to be when they can be released from care. So often, like, this notion of, like, pretend you're mentally ill, which generally isn't successful, is not good for severe crimes because you will be locked up basically indefinitely. Now, if you're legitimately unable to determine right from wrong, that's the best thing for you and for society, but it's not really a cop-out card defense that people use, as much as crime shows like to talk about it. Now we move on to the burden of proof, which I mentioned a little bit earlier about beyond reasonable doubt. So the civil standard of proof is on the balance of probability. So if you go to jury of 6, you have to have been determined that, yeah, this probably is the case. It doesn't matter about the number of jury. I don't know why I was thinking about it that way. Criminal case is that it must occur beyond reasonable doubt. Now, that doesn't mean I can think of some insane explanation why, I have an axe in my hand and someone in front of me has an axe in their head, has an axe mark in their head. Like, it's not like, oh, someone ran into the room, smacked them, wiped all their fingerprints off, drugged me, and then put it in my hand. Oh, officer, I didn't do it. That's silly. Like, technically, yeah, could that happen? But it's not a reasonable explanation. So any defense or alternative explanation to the events in question has to be unreasonable. Now, the classic case that demonstrates this difference between the criminal and civil standard is actually, I think, the O.J. Simpson case. O.J. was obviously found not guilty in a criminal court because his lawyer was really, really great at emphasizing that there's doubt. The LAPD did do dodgy stuff. They did plant evidence. There is no way to know what happened. Now, let's be real. He did it. But there was enough reasonable doubt that could be cast that said, well, I guess this could be a setup. Contrast that to the civil case that Nicole Brown's family brought against O.J. Simpson, which was wrongful death. He was found liable because on the balance of probabilities, yeah, he probably killed her, right? So that kind of demonstrates the difference. Some 2 key recent cases in Australia. We have Pell against the Queen, so Cardinal Pell's case. The High Court one specifically explains beyond reasonable doubt really well, though still notes that the evidence was quite compelling, so kind of says that it's a very hard call, basically. And the Queen against Dawson, or Regina against Dawson. So that's the Chris Dawson case, which is the opposite in terms of the Supreme Court justice did an excellent job and a very long judgment, systematically saying someone offered this explanation, that cannot be true. So again, if you want to read these 2 cases, I would really recommend it, if you would like to, and they'll help you understand some things better. Keep an eye on the Dawson case. He will appeal. I imagine that will end up in the High Court. Though it will be interesting because that was a judge-only trial in the Supreme Court, so it's a bit hard to say that the judge didn't know what he was doing versus a jury. Now, to look at a critical lens of criminal law, why do we have a criminal law system? Now, we've said it's to have a moral meaning, basically, to society, but the governments generally hold that there are 5 main reasons. Deterrence, for both the person that committed the crime to be deterred in the future or others like them. Punishment, to just straight up say that's wrong. There are consequences to your action. Protection of the community. Reform, to reform and rehabilitate a prisoner. And to denounce from a moral perspective. Society does not stand by this. Now, most crimes and punishment can be slotted into some category here. But there are some, as I mentioned before, because criminal law is quite often very fluid, sometimes there's ambiguity in cases where there has been a horrible accident, for instance, and someone has died, but it was accidental. Now, you might say, yes, deterrence is our main, it stops people from maybe making the same mistake, or it says that, that type of thing. But really, if someone's been in a horrible accident, they're probably punished enough. They're probably not going to commit a crime again, so they don't need the community protection, there's maybe no reform because, again, it's not going to happen again. So comes more cases that don't fit into one of these four will generally just be about denunciation or the moral meaning. So I think the word that New South Wales uses is protection, side deterrence, retribution and reform. I can't find the actual word that's often used. That's okay. Denunciation, yeah. That's the word that the ALRC uses. Someone else has used it, but that's okay. Generally, if it doesn't fit into deterrence, punishment, reform, or protection, it's generally denunciation. That's bad. You shouldn't do it. Which can sometimes feel a bit weak when, obviously, prison's not a very pleasant place to be if you're not a hardened criminal, or even if you are. So that's why there are things like not using sentencing, right? Sometimes you won't receive a custodial sentence. You'll receive, community corrections order. Before you get into sentencing, bail is a very controversial thing as well at the moment. It's generally used to protect the community or ensure that the accused is within the system. So if you think they're not going to come to the next trial. But it is ultimately incarceration before guilt has been determined. So for Victorian statistics, 50% of women in Victorian jails are not sentenced at the moment, and a percent of that have not been found guilty yet. And 51% of Indigenous people in Victorian jails are also unsentenced and may not have been found guilty yet. So in terms of there's a strong balancing act that has to happen with bail, with protecting the community, ensuring efficiency of justice, but also ensuring that people aren't in jail necessarily. So bail is also an interesting flip on the usual criminal law dynamics. So normally the state bears the burden to prove beyond reasonable doubt, to prove why a certain sentence should be given, etc. Bail is actually the accused must prove why they should be given bail. What is the exceptional circumstance that says they should be sent home? And often, instead of if a person is released on bail, they might get check-ins or curfew or tracker, some type of something like that. The fact that the onus is on the accused, though, is a bit troubling when we get to the notion of unequal representation. So sentencing happens after that, after the guilt has been determined. Magistrates and judges and justices must take into account some elements. So objective seriousness, aggravating factors, so if the victim is a younger age, victim impact, the consequences of the crime, if the offender is really, really old, or if the offender has some type of terminal illness, and heaps and heaps and heaps and heaps and heaps more. They don't have to take into account every single one, but they need to have taken into account these critical factors. Some crimes have a mandatory term, which is quite controversial. Judges don't like it because it takes away their flexibility and much more American. Some states don't rely on that as much as well. The other thing that must be taken into account is if an offender has pled guilty, they can generally receive a percent of time off their sentence to save court resources and encourage responsibility. So this is what the criminal law process looks like. I think it's upside down mentally in my mind. So you have an offence. There is an offence that has been committed. A copper could go, yeah, no, just don't do it again. Or it can go to the court. The court can say, no, you were acquitted, you didn't commit this crime. If it's a serious offence, it might be put up to a higher court, like a district court, or alternatively, there'll be a sentence. You may not appeal, it's $300, you might choose to cop it. It's 3 years in jail, you might choose to appeal that. Goes to a higher court, so you're either acquitted, sentenced, you can appeal, etc., etc. You can go all the way up. In theory, you can keep appealing it all the way up to the High Court, which I assume we will see in the Chris Dawson case, and we did see in the George Pell case for two, prominent ones. Now, I did say, I didn't leave it in the slides, mens rea and actus reus refers to the mental state and the act committed. The majority of crimes will need to have both elements proven in order for the crime to be proven beyond reasonable doubt. Now, the act will generally be straightforward. It is either a positive act or an act or omission, i.e. you either did something or you deliberately did not do something that resulted in something. The state of mind, again, is generally will give the differentiation between certain charges. So, for instance, murder will have the mentality that you intended to cause severe harm, murder, or were reckless in not anticipating it would happen. So the case in that matter, there are two. There's one where a guy drove his truck through, not a petrol station, like a diner, and he tried to say, I didn't realize anything bad would happen. And they were like, yeah, okay, but you probably should have. And the other side of that one about the act or omission, the case of Ebony, don't look it up, it's a bit grim. It's not a bit grim, it's horrifically grim, which is a child neglect case, is about the choice to not do something and that reaching the standard of murder. If we go back to the mens rea, the relevant state of mind, if you, for instance, didn't intend to and you weren't reckless, but someone still ended up dead, that's where you might move to manslaughter. So you generally have to have both. It's a really good way to visualize it, and I'm annoyed I didn't make the slide because I had a plan and then obviously it left my brain. A table is a great way to visualize it. Like, what's the crime? Manslaughter. Mens, actus, that type of thing is a good way of looking at it.